Morfe vs. Mutuc, GR number L20387, January 31, 1968. Facts: Appellee Jesus Morfe filed a complaint before the Court of First Instance or CFI questioning the provision under Republic Act No. 3019, or the Anti-Graft and Corrupt Practices Act, whereby government officials are required to periodically file a sworn statement of financial condition, assets, income, and liabilities. He alleged that the said provision is unconstitutional because it violates his constitutional rights to due process, right to privacy, right against unreasonable searches and seizures, and right against self-incrimination, as it compels him to disclose his assets and liabilities while holding a position of public service, premised on the unwarranted assumption that they are corrupt at heart unless they comply with the said requirement. The CFI declared that the provision is unconstitutional because the requirement exceeded the permissible limit of police power, and offensive to the Due Process Clause. Thus, the present petition for declaratory relief filed by the appellant's Executive Secretary and the Department of Justice. Issue: whether or not the provision is unconstitutional. Held: no. The reasonableness of the law made the law valid and within the ambit of police power. In the present case, Republic Act 3019 was enacted by Congress to curtail and minimize corrupt practices in the government and maintain a standard of honesty in the public service. It is intended to promote morality in public administration, considering that a public office is a public trust. Thus, it would be unreasonable to ignore the harsh reality of public service to condemn as arbitrary and oppressive the requirement under the said law. The relationship between the requirement of the law and its objective is not so far-reach because it emphasizes that in subjecting him to such further compulsory revelation of his assets and liabilities, there is no constitutional intrusion into what otherwise would be a private sphere.